Yeah, so this evening we first of all want to discuss application for directions, case management, and witness statement. Now, just before we discuss this, you notice that we have already started some of the pre-trial protocols from our previous lectures. We talk about discoveries, we talk about interrogatories, we talk about admissions, isn't it? And then we discuss applications generally. Because of the homework I've given you, ordinarily I will have a recap, but I'm not going to do that because we are not able to do that. That is why I give you the homework. So if I'm to do that, to defeat the exercise that we are given. Yeah, so let's continue to our class. So after pleadings close in civil suit or litigation, the next stage is application for what? Directions. And now when we say pleadings have closed, I hope you understand what we mean. When our pleadings close under the law, yes? Yes, let's hear you. After reply has been filed. 7 days after. 7 days after reply has been filed. Right. Yeah, so in terms of case management, when we say case management, it's nothing more than all the processes, the arrangements, which will have to be made to ensure that the case is disposed of efficiently, effectively, and expeditiously. So the whole gamut of arrangement and process is what we call case management. So when you hear the judges or the court talking about case management, that is the idea. All the things involved, like the processes, the techniques, the arrangement, the planning, which will have to be made so that you're able to dispose of the case. When we say dispose of the case, when there's a judgment, isn't it? When there's a judgment, when the parties they know their fate, then the case has been disposed of. So all the things which we need to do to get to that level is what we call what? Case management. So we are saying that application for direction is the primary case management what? Mechanism we have. It enables the court to identify the issues in disputes. What is the point of contention? Remember, we've done pleadings, and pleadings are supposed to narrow the case of the respective parties so that through pleadings we're able to know the rare controversy, because there will be some admissions and there will be some deniers. So as we take care of those pleadings which have been admitted, and then we take care of what is not admitted, what is denied, we'll be able to work our way to know the rare issues in what? In the disputes. Because the whole point about trial is to resolve the issues in dispute. But how do we know the issues in dispute? Again, application for direction will enable the court to organize the evidence required for trial. The evidence will need to be organized. We have all manner of evidence and so on. So the court will have to have an idea and assist the parties and give the necessary orders or directions to enable the evidence at the right time to be organized for the trial. And again, application for direction also enables the court to regulate disclosure of documents. We've done discoveries and interrogatories. Sometimes, even as at the stage of application for direction, some discoveries or some interrogatories might not have been actually carried out by a party, and then the court may have to come in, isn't it? Yeah, and so at the application for directions, all those outstanding issues can also be dealt with, as we will see. Again, application for direction enable the court to direct the filing of witness statements. So now, with the CI 87, which is amendment to the CI 47, there's something called the witness statement. Previously, when we were having a trial, a party and the witness will have to enter the box and give a long narration, or what they call the evidence in chief, the examination in chief. And then the judge will have to record, everything will have to be typed. It's all waste of time. Since you're just going to narrate, and you know the thing you're going to narrate, why not write it in your house or your office? come and file it. So that when you're doing the trial, you will just identify it as what we did, and then the court will adopt it. Then we save time. So during applicable direction, the court will give orders directing the party to file what? Witness statements. And again, direction also enable the court to explore settlement possibilities. No, we have a CI 133. No, as part of the application for directions, the court will have to, in 101, the court will have to find out whether, of course, now we even have like what we call the mandatory, court-connected mediation. You have to let the parties try and explore settlement if they can be assisted. We have a trained ADL experts connected to some of the courts. They can help the parties either by mediation or even in extreme, some cases, they can be left for arbitration or whatever. Also, once that is possible, the court will help the parties to do that. And if that should fail, of course, timetable will be fixed for trial. So all these things will have to be done under the application with direction. And as we know, Order 1, Rule 1.2 talks about the objective. Remember that these rules have been interpreted and applied so to achieve what? Speedy, effective justice, avoid delays, unnecessary expense, and ensure that as far as possible, all matters in dispute between the parties may be completely, effectively, and finally what? Determined. Yeah, so that objective is actually actualized during case what? Management as well. So Order 32 of CR 47 governs application for direction. And if you look at Order 32 Rule 1, we are told that in every action to which the rule applies, application for direction shall be made to enable the court to consider preparation for trial so that all matters which have not already been dealt with may so far as be possible be dealt with. And B, directions may be given as to the future course of the action as appear best to secure the just, expeditious, and inexpensive disposal of it. So, all outstanding matters, whether somebody requested for some documents to inspect as part of a discovery and it has not been carried out, or certain interrogatories were actually sent and they have not been answered according to the format provided in the rules. And then a party will need a court to actually come in and make some further orders. They will be done at the application for direction. And if you look at the B, it's quite general. Means that the court has a wide discretion in terms of how it will give direction with the future conduct of the case. So, at the pleading stage, the parties are in charge. When pleadings close, the courts or the judges is in charge. Now it becomes the judge's job or responsibility to help to dispose of the case. And then disposal of the case means that you must have a judgment or a ruling, as the case may be. So whatever needs to be done so that you'll be able to make that progress towards the stage of giving judgment, we need to do that. And that is part of what the B is talking about, that direction may be given as to the future course of the action as appear best to secure the just, expeditious, and inexpensive disposal of it. So, all pending interlocutory matters before the courts will be addressed as part of the application of directions. And two, it also allows the court, as we have explained, to organize the future conduct of the case, including discoveries which have not been carried out, interrogatories, admission of facts, settlement of issues for trial, and the mode of trial. And this is where I would like to point something out. Lawyers don't pay attention to settlement of issues of trial. And then they will just write anything, they go and dump it on the court. So that when, at the end of the trial, when the court is writing the judgment, and the court too, sometimes we also, some of our colleagues too, we also don't pay so much attention at applicable direction. But if you look at the 32 well, if you have used it well, it will make case very efficient for the parties and also for the court. But the 32 don't use it well. So the lawyers, after that, they'll just put down application for direction, they list anything. Then all that a judge will do is that, okay, the issues filed are adopted as the tribal issues. And oftentimes, the lawyers and even the court, that's the judge, will not have applied their mind critically to the pleadings to find out that if you read the statement of claim, statement of defense and counterclaim, and then defense to counterclaim and the reply, or reply and defense to counterclaim, as the case may be. What is the rare point of dispute? Essentially, so what are the major issues, the major points of disagreement based upon what we read? For which reason the court will need to take evidence to be able to answer those questions. We don't often do that, but that is how it's supposed to be done as part of the application for direction. So if we read Mr. Kwame Tete's work, he, for example, made the point that application for direction is a stock-taking process aimed at saving costs in litigation by avoiding needless interlocutory applications and dispensing with unnecessary witnesses through proper case management by the judge. I mean, if you do proper application for direction, you guide the parties to think, closely about their case and the witnesses that they need. You don't call witness for calling sake. As you know, it's not the quantity which matters, but it's what? Quality. You can have only one witness, or sometimes maybe just only the party. But he has a requisite what? Evidence. And that will suffice. So if you look at application for direction in modern litigation, the judge must actively manage the litigation. And you manage it as we saw by Order 32, Rule 1A and what? And B. So if you look at the case of the Smith against Blankson, 2007-2008, Supreme Court of Ghana Law Report 374, the court, among other things, Smith and Blankson. So the Supreme Court will remind us the need for trial judges to play a proactive role in setting down issues for trial and ensuring effective case management. So it is important. So if you are a court and of course you also become a magistrate, circuit court judges, high court. So you are learning as lawyers and future judges as well. So when the pleadings have closed, you are going for application for direction. You must actually, and the both lawyers too, you must study the pleadings and ask yourself the issues which have been proposed by your opponent. Are they the rare issues which need to be addressed? Or some issues have been what? Have been left out. And then the court will have to engage the pleadings and ask itself, what are the rare issues? So that if the court is being proactive, some of the issues that are being proposed, if the court has thought through, the court can point into them that this and this and this, the court doesn't think that's important or issue. And sometimes some of the issues are even discarded. But that can only be done where you have properly considered what the pleadings. So who must apply for directions? Well, if you look at the 32 rule 2, it is the duty of the plaintiff. So in every action to which rule 1 applies, the plaintiff shall within 1 month after pleadings in the action after the pleadings in the action are closed, so we file notice of application for direction for service on all other parties to the action. So it is the duty of the plaintiff, first and foremost, to file application for direction. And this is supposed to be done within 1 month. So after pleadings in the action are closed, and we've come to know that pleadings are closed 7 days after filing of what? Reply. Or where no reply is filed, what is the position? Where no reply is no. Where there's no reply, how do you know that the pleadings are closed? So when is reply supposed to be filed? How many days after service of after the statement of defense? 7 days. 7 days. Good. So if reply is not filed, 7 days, after another 7 days, 14 days, pleadings are what? Are closed. Because not until the time for filing reply and the period has elapsed, we cannot say that reply will not be what? Will not be filed. Good. So whatever it is, pleadings are closed. Now, within 1 month from that, it doesn't mean that I have to wait for 1 month, but the law says within what? 1 month. Yes. If you are a plaintiff and you believe in your case, because of course, if you don't believe in your case, why will you go to court? So if you believe in your case and you want to win your case, you'll be interested in letting the process run fast, isn't it? Yeah. So you'll be very proactive. You can even file the application for direction just a day after the close of what? Pleadings, so that the process will go fast. And we are told that there should be 8 days between the date of service of notice and the day named in the notice for hearing of the application. So if you get the application for direction filed today, it cannot be heard until after what? 8 days. Now, why is it that it is first and foremost the plaintiff whose duty it is to file application for direction? You actually started the case, isn't it? So once you started the case, you have the primary duty of prosecuting the case diligently and preparing it for what? For trial. But there are exceptions where directions may not be necessary. And also, we also have a situation where if the plaintiff does not file for the application for direction, a defendant can also what? Can also file. A defendant can also file, whether the plaintiff does not file. It is expected that the plaintiff will do that, but if the plaintiff does not do that, the rule also allows the defendant to also file. And especially the defendant, if the defendant may file or the defendant may move for the case to be dismissed. So 2 things, where the plaintiff has defaulted, the defendant may decide to file the application for direction, or the defendant can just file a motion and invite the court to dismiss the plaintiff action for want of prosecution, i.e., a failure to file application for direction for the case to proceed to trial. Of course, when the application is brought, the court may not grant it. The court can also treat it as an application for direction, adjourn it, and order the parties to file their issues, and maybe inflate costs on the plaintiff. Yeah, so that can also be done. We have exception. We have cases in which you don't need to go swiftly by direction. You don't have to do direction like order 14. No, remember order 14, summary judgment proceedings. Yeah, so summary judgment proceedings, there's no need for what? Application for direction. And the rules actually have excluded that. If you look at the order 32 rule 1-2, so it does not apply to those kind of things. So it makes reference to actions given, actions in when directions are given under the 11 rule 19, the 14 rule 6, the 25 rule 7. These are proceedings which have their own unique application. So this one is a general application for direction, but the rules also contemplate that for certain type of procedures, it may be necessary for directions to be given. So if you are doing the summary proceeding, for example, we have that. So if you look at the 14 rule 6, somebody should look at the 14 rule 6, for example. The 14 rule 6. We have directions there. Where leave to defend is given or execution stayed under rule 5, the court may give such direction as to the further conduct of the action as may be given on an application for direction, and may order the application to be sent down for trial forthwith. May order the action be sent down for trial forthwith or assign it as the court considers what appropriate. So, where an application for summary judgment has been brought, and then the defendant has brought affidavit to try and show cause that the summary judgment should not be entered, for example, or the courts may use that opportunity to give various directions. The court may say, okay, there are tribal issues, but we're not going to wait and allow things to follow in the usual course. The court can give specific direction regarding expeditious trial. So when it comes to trial, so long as the court is being fair to both parties, the court has a lot of a free hand. The most important thing is fairness to what? To both parties, and not descend into the arena of what? Of conflict. Yeah, so, and that is why, Order 32 is saying that when it comes to cases in which directions have been given under Order 14 says that summary judgment proceedings, then the general application direction does not apply. So you don't need to follow that one. Matrimonial proceedings, so that's another one. When it comes to Order 65, you do family law in the second part 2. When it comes to divorce proceedings or matrimonial proceedings generally, we don't do application for direction. We just do a setting down the action for trial. Because in the matrimonial matters, as we'll learn later on, the basic test, has the marriage broken down beyond reconciliation? That is the most important issue. And all the other things, unreasonable behavior, adultery, whatever, all those things are meant to help the court come to determination as whether the marriage has broken down beyond what? Reconciliation. And then there's only one relief or one remedy in divorce cases, which is divorce. The solution is the only remedy. All the other relief, call them ancillary reliefs. So all the other things, alimony, custody, whatever, they are all, we call them ancillary. The only relief in matrimonial proceeding is what? Is divorce. Or if you are going to do what they call the annulment, in which case the court will say that the marriage was even not valid. That one is a different thing altogether. Good. So matrimonial proceeding is excluded from Order 32. So when you are doing family law, don't go for Order 32. Now, one point I want to note before we move on is that it is wrong to file reply and application for direction together on the same day. It is wrong. I hope you understand why it is wrong.
Yes.
Are you all convinced why it is wrong to file reply in application for direction?
Yes.
Your yes is weak.
Oh, yes.
The chorus is weak. Yes. So you have some practitioners, whether out of laziness or they don't look at their rules. They file their reply and then the same day they follow through with the application for direction. You read order 32, no rule 2, together with order 11, rule 19. The combined effect of these provisions in order 32, rule 2. The 32 rule 2 says that within 1 month after pleadings are closed, isn't it? Good. Now, if you look at order 11, rule 19, order 11, rule 19, close of pleadings. The pleadings in an action are closed at the expiration of 7 days after service of the reply, or if there is no reply but only a defense counterclaim after service of defense word counterclaim, or if neither reply nor defense counterclaim at the expiration of 7 days after service of what? Defense. You see how you all misled the court. You said 14 days, but the law says 7 days. That is where there's no reply. If there's no reply, because after defense are filed, you have 7 days to file reply, isn't it? Yeah. Good. So after expiry of 7 days, if there's no reply, then pleadings are what? Are closed. So I was making the point that by combining effect of order 30 rule 2 and order 11 rule 19 of CR 47, the reply and application for direction cannot be filed together. Now, what happens where there's a failure to apply for application for directions? So the 32 rule 3 will remind us that where the plaintiff does not apply for directions in accordance with 2, a defendant may do so or may apply for the action to be dismissed, as we talk about. So you have 2 options as a defendant. You either apply for directions or apply for dismissal of the action. If you're a defendant and your client's case is no good, you have to be very serious with the rules and take advantage of every procedure. You may end up getting some small costs, which will, even if your client is going to lose the case, at least your client will have earned some costs to cover some of your legal fee and not be too worse off, isn't it? So assuming the plaintiff failed to file the application for direction, you file motion that the action should be dismissed. Then you go and you take a very stiff position. The court will not mind you, but the court will give you a massage balm, the nature of costs, and then the matter will continue. If you look at the Islamic mission against Ghana Muslim mission, the 1997-98 Ghana Law Report 953, the Court of Appeal makes the point that the failure to apply for direction does not automatically invalidate proceedings. So it is not the case that because the plaintiff did not apply for directions, then the proceedings are what? Are invalid. Sometimes it may even happen, particularly so where courts judges change. Where a case is transferred from one court to another, or the judge is transferred, another judge takes over the court. If the judge does not audit the docket, auditing the docket means that take your time to review the file and find out, understand the situation of the case, so that you know further directions will give for continuation, including adoption of proceedings. That may not be done by maybe sometimes inadvertently, and then they will just continue with the trial. And the lawyers will also not assist the court, so the trial just will continue. Then later on, when judgment is written or being delivered, it will be there and then that you realize that, oh, Directions will be not taken in this case. So that is where this authority become important, that the failure to comply to seek directions under the 32 does not automatically what? Nullify the proceedings. And Omane against Poku also made the same point. Omane against Poku. 1973, 2 GLIs 66. The court made the point that omission to take an application for direction will not invalidate the trial where the issues for determination are already clear from the pleadings and evidence. I mean, despite the fact that the failure to set out the issues for directions and for that matter direction will not automatically nullify the trial. It does not mean that it should not be done. If it is done, it's better for you as a party and also help the court. Because when we are doing the trial, in terms of objection to admissibility of evidence and so on, sometimes a person will raise objection and make the point of the relevance that this evidence is not relevant to any of the issues or any of the things that the court need to determine as a whole. And then the onus will be on the party preferring the evidence to actually make a case to convince the court why the relevancy requirement is what is met. And for that matter, admissibility should not become a problem, as it were. Also, in the case of Amoako against Hansen, 1987-88, 2 JLR, page 26. The Court of Appeal, strangely, took a view, but that view is no longer a good law. They took the view that the failure to serve someone for direction. In the past, we used to call application for direction summons for what? For direction. Under the repeal LN 148, the civil procedure rules that we learn under. So those who learn under LN 148, these are very senior lawyers. And those of you who are learning under CH 47, you are babies. So under the repeal LN 148, we used to call the summons for what? For directions. But now that has changed. We call it application for direction. And for good reason, because what is done application for direction here is more expansive than what used to be the case under summons for what? For direction, as it were. So Amoako against Hansen, essentially, is not a good law because of the Supreme Court decision Boache against Tutuye Hene. Boache against Tutuye Hene, 2007, 2008. SCGLR 970. Tutuye Hene. Yes. No, the Court of Appeal held that failure to serve someone for direction render the proceedings null and void. So that was the position. But I hope when I mention the case, you go and read them. We don't just take the one sentence associated with the case as enough. You have to go and read the case. And the good news for you is that now the case is just on your fingertip. If you're on your phone, when you are sitting in the bus, when you are sitting at a funeral, when you are sitting even on the toilet, you can be reading cases, isn't it? On the phone. Instead of doing TikTok, Snap, and all those social media, you can be reading cases. So now, unless you decide not to read, then it's a different thing. But if you want to read, there are so many what? opportunities that you can read.
Yes.
Even when you are at a funeral or you're at a social event, when people are jesting, you pretend to be busy on your phone as if you are sending message, but you're reading the case. Yes. We call it effective time management. Yeah, so Boashia and Tutuyahine disagreed and actually made the point that non-compliance, the requirement to apply for direction, should ordinarily be treated as an irregularity rather than what? A nullity. Unless it will result in miscarriage of justice. And with the application for direction, one is not applied for, will it result in miscarriage of justice? Well, it will depend upon the situation. So matters to be considered by the court during application for direction. If you look at Order 32 Rule 6, these have been set out, and I'm speaking to them. So I expect you to go and read the law. Particular matters for consideration. That on the hearing of an application for directions, in the court shall in particular consider, if necessary on its own motion, whether any order should be made or direction given in the exercise of any of the powers conferred under Part 8 of the Evidence Decree, NRC Decree 323, Order 16 Rule 5, Order 33 Rule 42, Order 33 Rules 2 to 9, or any other enactment. So, because application for direction is the primary case management mechanism, if, for example, you remember you're doing a lot of evidence now, you know the rules on hearsay evidence. Part V8, exam on hearsay. What is it about? Part 8 of the Evidence Act, exam about hearsay. Look at your law. Yes, so, for example, declarant available or not available and so on, sometimes there may be the need for certain preliminary things to be done before issues of admissibility of certain evidence may even be dealt with. So that will have to all be factored into at the application for direction stage as it were. There may also be issue of expert evidence. If expert evidence will be necessary during the trial, particularly when it comes to land cases, for example. Now, if you look at the Land Act, it is mandatory that in every land case, there must be what we call a composite a plan. Otherwise, you cannot give a declaration of title or give a perpetual injunction. You must know the true identity of of the land. So you have to appoint a surveyor with the Lands Commission to make available the surveyors as well. So that will have to be dealt with during the application for direction stage as it were. So the court will make the orders either on its own or on application by a party, and then order that a court expert or a surveyor or any other officer should be appointed. And then the court will direct the parties to file instructions. In other words, what do you want the court expert to look out for from your point of view? And then what information, what documents, if it's land, your site plan, and you have to make it available so that the expert will fix a date and invite you to go to the locus. That is the place where the land is. Go and show me your land. Show me your land as it were. And from the point of view of adjudication experience, if you're a lawyer and you're doing a land case, it will be prudent when your client comes to you, don't just rush to just write the relief, declaration of title to this, bounded by this and that. It's better if you can even get your own private surveyor to test your client's site plan or the whatever indenture the client is having in terms of like the map or the site plan. Get your own private surveyor to test it, to try and locate it. To try and locate it and then cross-check it with what is held in official records, so that you have a clear idea of what it is. And when you go to the court and you're doing the trial, there's no surprise for you when a court expert is appointed. Because often what happens is that, and that also shows that we don't do our work well as lawyers. Because when the court expert is appointed and he goes to do the work, then he brings a report. Then you find the situation, maybe what your client showed during the work is different from what is stated on the site plan. So the question is, if you have done that on your own before going to court, you have seen the problem, isn't it? And that's what informed the strategy you should take to manage your case, isn't it? And there'll be no surprise for you. So this is something that you have to actually, if you want to be a good land litigator, as it were. Of course, in terms of Order 32 rules, if we are to break it down, we also notice that the courts also make directions concerning, when I say the expert evidence, not only surveyor, depending upon the case. So let's take note of that. And again, application with direction is not one day. Application with direction, oftentimes, practitioners think that application for direction is just what we call an event. No, it's not just one day. It can be, application for direction can be more than once. Because you go to the court to seek direction. Either you have something in mind, and then you take it to the court for the court to validate it as to how the matter should progress, as it were. Again, admissions and agreement during directions. Order 32(7), that during directions 32(7), at the hearing of an application for direction, the court shall endeavor to secure that the parties make admissions and agreements as to the conduct of the proceedings which ought reasonably to be made by them, and shall incorporate in the order of the application any admissions or agreements so made, and any refusal to make an admission or agreement, subject to any special order as to cause being made at the trial. Then 7.2, nothing in this rule shall be construed as requiring the court to endeavor to secure that the parties agree to exclude or limit the right of appeal. Good. So when it comes to the direction, it is permissible and is actually encouraged for the parties to make necessary admissions regarding how the trial should be. Sometimes there are certain matters, if you look at it and nothing can be done, there's nothing wrong. If you say that this aspect or this particular relief, maybe there are about 7 reliefs what the plaintiff is looking for, and you look at it and about 2 of the reliefs, they actually agree that the plaintiff should have it. It's not necessary for you to keep quiet and allow the long haul trial to be what you've gone into. That is why Order 32(7) is saying that agreements or admissions can be made at the direction stage, and the court will have to record that. The only thing the court will not facilitate, the parties will agree on, to say that there should be no appeal. No, that one is not a part of it. But apart from that, all compromises which the parties want to make it can be made under order 32 reward with 7. Now let's talk about the yes.
Please, can you explain what the rule 7 again?
7. Okay. So the rule 7 is asking the court to make good attempt. So that is the rule say that shall endeavor. So the court should make a good effort to encourage the parties to either make necessary admissions or reach agreement regarding the conduct of the case. And that will include either certain, for example, when it comes to, we have this rules on admissibility and so on. Assuming the strict requirements of admissibility have not been met, okay? And then, but both parties knows that this thing we are talking about, that is a position. They can reach a compromise and say that, okay, this particular aspect, we don't want it to go through the crucible of the law of what? Of evidence. This person say, okay, we agree that this is a position, regardless of the fact that according to the resource, no stamp duty vote is paid. But we agree that this is what happened. That is permissible. So long as order 3272 is respected, that the court is not letting them include in the agreement that no party shall have a right of what? Appeal. Okay, so let's talk briefly on the settlement of issues for trial. Settlement of issues for trial. So the settlement of issues for trial is, if not the only, that's one of the most important functions of application for direction. And our settlement of issues for trial, that is trying to find out what the tribal issues are. So the judge has the power to identify and formulate the issues. That's going to be determined during the trial. The lawyer who filed the application for direction, be it the lawyer for the plaintiff or the defendant, as the case may be, their issues are what we call just a proposed issues. It is the court which has the final say as whether those issues are actually the issues which need to be adopted as the tribal issues. And that is why, if the application for direction was filed by the plaintiff, the defendant gets it and said that no, I think that there are 3 other issues which are important, but they are not here. So he will file the additional issues, propose additional issues for what? The trial. So during the application for direction, the court will consider all. And then if it's convinced that all are really important, then they are combined or consolidated as the issues for what? For trial. So that is how it is. And how will the party actually go about? How do you go about trying to formulate the issue? And with the courts, you have to carefully analyze the pleadings. That's the first one. And 2, identify the rare questions of law and facts in dispute. I'm actually your examiner. I'll give you about 3 pleadings, and I'll ask you to draft application for direction, especially the issues for trial. But thank God I'm not your examiner. If I'm your examiner, I have a lot of questions for you. Yes. And the second one, identify the rare questions of law and facts in disputes. And here, this is where the difference comes. When we are in the law school, when we are writing problem-based questions, we are doing the IRAC. In the law school, because we don't do evidence stuff, when we are doing the IRAC, identification of issue, we are not interested in the facts, isn't it? as to whether something happened or did not happen in terms of actual happening. We are rather interested in the legal question. But then when it comes to applying for direction, we're interested in both. We are interested in both questions of what? Facts, and then the questions of law, and then the mixed question of law, in fact, as the case may be. If you look at, there are plethora of authorities, I'll just list them. Dam and Nado, if you've read it. And this is a 2 200. The importance of framing the issue. Ujo and Kunte. As for the cases, I decided to go easy with you. The reason being that civil procedure, every point, you can get so many cases. But as I said, it's not so much about just the litany of cases, but you first and foremost understanding the principle and know how to draft them. Now, if you look at these cases I'm going to list, Dam and Nado, Minister for Local Government, again, Nia Cressy II, Kwate and Kwate, Pa and Bedia too, Kujo and Conte, all of them. And if you read Mr. Kwame work, they are there, all of them. What they remind us is that when it comes to framing the issues, what should be focused on the essential elements of the cause of action and the defense, and not a question of reproducing every allegation contained in the pleadings. What happens in practice is that for many lawyers, because we don't apply ourselves to the skill of drafting issues properly, they will take almost every amendment, they turn it into issue by doing order or not, order or not, order or not. So you may end up having plenty issues. Yes, but that is not the proper thing. It's not just every paragraph which will turn into issue. The rare cause of action of the plaintiff, what is it? And then what are the elements, like what in law constitute that particular type of cause of action? Then that should guide you as you read through the pleadings, be able to find out what should be set out as as issues. Or the defense of the defendant. What are the rare constitutive elements? Now, what is the duty of the court and the parties? The duty of the court and the parties, or the 32 Rule 5, when it comes to application for direction, both the courts and the parties have their responsibilities when it comes to application for direction hearings. The court must determine whether all matters required under Order 32 can be dealt with immediately, or whether some issues should be adjourned to a later stage. And that is why I said that application for direction is not just one day. The court doing it can adjourn aspects of the issues which need direction to some later stage, or some other things may even be made. All those are permissible. Or sometimes when it comes to like debt litigation, debt recovery action, the court may even consider it necessary to appoint maybe either an accountant or a referee, especially to go and do certain arithmetic or do certain complex interpretation of the financial statements, or as it were, and then file a report as part of the court dealing with the matter. I think my battery is going off, so we have to change the decision.
Yeah.
So this side, yes. Yes, I said the same way. Yes. You can call it. Put that one on. Okay, so let's continue. Let's continue. Now, just as the court has a responsibility to deal with all matters which can be done with immediately, or matters which have to be adjourned. The parties and their lawyers have also got a duty to cooperate with the court by providing relevant information and documents necessary for the determination of the application. Mind you, the case is for you, the parties. So you need to cooperate with the court to be able to progress the case towards a judgment. And failure to comply with directions may attract sanctions, including adverse orders as to cost, striking out of pleadings, dismissal of claims or counterclaims. Can you imagine when, under what circumstance, a claim may be dismissed as part of the application for direction? And mind the application for direction here also include dealing with all outstanding matters. For example, if there are outstanding interrogatories or outstanding discoveries which have not been carried out and are still outstanding, at the application for direction, the court will make orders to get those things done. Yes. When there are admissions. That will not be dismissal. That will bring about a judgment on admission, as it were, isn't it? By one of yes. But then we talk about it previous class, where, for example, interrogatories have been served on you are supposed to answer, and a period is prescribed. You don't answer, or you answer, but you give inadequate or what they call insufficient answers, as the law says. And then the court order you to provide more responses, and you are still disobeying those orders. One of the consequences could be, if you are the plaintiff, your action could be what? Dismissed, as it were. Or if you are a defendant, your defense could be strike out, as it were. Yes.
On the court deciding on issues with the parties, sometimes read cases and the court goes like, these are the issues the parties have presented, but then the action can be decided with these two issues, and then the court goes on to address these two issues. Would that mean the court didn't pay attention to it during?
Good. And it happens all the time, and that is why the jurisprudence or the case law has come to say that a court is not bound necessarily to deal with issues which were set down at the trial, but issues which the court consider as arising from the evidence and the pleadings that need to dispose of the case. Now, what you said happens because of what I just complained of, that we are too casual about directions. There are not all courts, but some courts and a good number of lawyers are too casual about what? About directions. And because of that, we just put any issues there. We don't apply our mind to the pleadings closely at that stage to interrogate as whether these are the rare issues which need to be determined to dispose of the controversy. But then when it comes to judgment writing, the court is more focused. And then at that stage, there's a critical attention engagement. And it will be there and then that the court will notice that, but these issues, these are all quote unquote rubbish. This is not like the rare a problem. But the rare problem is what? Is this. And that is why we have those situations in the case law. So it happens all the time. It happens all the time. But then when it comes, let's say, appeal, for example, equivalent of issues is what we call the grounds of appeal. But when it comes to appellate practice, where a ground has not been argued, the appellate court cannot base its judgment on without giving the party opportunity to argue it. So that if the parties did not set out a particular ground, but then you are looking at it and you think that this is a very important ground, and the court will have to give the party the opportunity to argue it before the court can deal with it. So that one is a bit different from when it comes to the trial stage.
Sir,
Yes.
yeah, I will be talking about the ruling and this and
Okay, explain. That the abuse.
yes. So more or less like bringing in facts, that's when actually perform the fact that has been taken for determination.
No, the ruling Henderson and Henderson talk about the res judicata abuse of courts. So, for example, there's a case which, okay, later maybe when we're supposed to give the judgment yesterday, but there was no proof of service of hearing notice. It's something about so there was a litigation in Accra, and then it somehow ended, and then somebody went to another region, I'm not mentioning the region, to go and start a case. The same parties, some of the same parties, but then some other matters are also coming up, and another person has taken a position that, this matter should be dismissed on basis of the abuse of court process. And then the ruling Henderson, red decatant, all those things. And now it has to be determined. So when it is determined, you will know. And then maybe we can discuss that particular, the facts as it were. Good. So before we move on to the next segment of our discussion, basically what you said is that appeal for directions serve three main purposes: identify the rare issues of trial, organizing evidence and witnesses, and then efficient and economical disposal of what? Of action. These are the basic things. Let's talk about case management. CI 87 and then the CI 33. Very important development in our civil justice system. So one thing we should remember is that we operate the classical adversarial litigation, and we are quite strict about that until recent, of course, as part of the Lord Wolf reforms. Lord Wolf reforms in the UK, which had a cascading effect on our eventual adoption of the CI 47, and which has further been refined by CI 87. So, under the old system, the court had a very, if you like, a passive role. Passive role in the sense that is for the parties to prepare their case and present everything to the court, and then the court will just decide. The court didn't care about how the party actually was organized their case, but that has all changed because it was just inefficient, excessive delay in disposal of cases. There are some cases, I think there's a case which was decided during the reign of the Chief Justice Wood, and we are told that the case traveled for almost about 40 years or 36 years. Yes. Yeah. They're just like that. So that is excessive delay in disposal of what? Of cases. Rising litigation costs, and then so many interlocutory what? Applications. And these are not good. And that is why we adopted a new judicial case management through the CI 87 and CI 33. So CI 87 has actually brought addition to Order 32. Order 32 ends at rule 9. Good. But then, sorry, rule 10. But then rule 7, we have addition now. So we have 7 what? 7A. And then what the 7A is saying is this, that when application for direction is brought, the court shall give direction for management of the case and set a timetable for taking and giving of directions, and the trial when on application for direction, the court has dealt with all of the matters. The court shall give direction for management of the case and set the timetable for taking and the giving of directions and the trial. Or B, fix a case management conference and give direction relating to management of the case as the court thinks fit. So you have I'm just reading from CI 87. You have the law read. That is why I'm reading very fast. So there's a new addition. It's not the case that we don't have case management. The application for direction, they're all case management. But now there's something called the case management conference, which is an add-on. So we have what we call the witness statement, as I hinted, which has now been introduced, that at application for direction, the court will order the parties to file witness statements. And the witness statement, all the witnesses that you are going to call, go to your lawyer and let them reduce their story, which they will say in the courtroom, in the witness statement. And when you are doing that, you should also be mindful of the rules on evidence. Because during the trial, when you offer it to rely on it, and in terms of this section 6 objection of the Evidence Act, the opponent may raise objection and admissibility. So when you are writing a witness statement, you be mindful of the rules of what? Evidence, so that you're able to avoid unnecessary objections here and there. So a witness statement typically will contain the identity of the witness. So when you are writing a witness statement, the identity of the witness, you are saying the identity, who is the witness? Let's start to enter the witness box. If you are leading someone examination in chief, after the person has been sworn, the first thing, you want to know the person's name. You want to know the person's business or occupation, isn't it? You want to know the residence of the person, as it were. These are the basic things you need to know as far as the identity of the person. And the same thing should happen in the witness statement. If you are dealing with an old, a very old witness, it is also, there are certain things which are not in the rules, but in practice, you have to pick it. You have to state the age of the witness, assuming you are dealing with a very old person. And that may be necessary when later on cross-examination is fumbling with maybe some recall. It will make sense that the person, for example, already is advanced in what? In age. And then as you advance in age, your memory is not as sharp as when you are what? You are young. But then if you didn't do that, it will also be difficult for you to explain those things away as it were. Then apart from the identity of the witness, it must also talk about the witness relation to the parties. What is the relation between the witness and the parties? You are going to draft witness statements, you should keep this in mind. So what is the relation between the witness, who is doing the particular witness statement, and the parties to the case? Then you must also talk about the evidence the witness intends to give. So now, tell your story concerning the case. And you must be mindful of the rules against a hearsay, isn't it? And then the permissible exceptions. So when you are crafting the witness statement, you should be mindful of all those things. Also, the witness statement must also contain the document the witness will rely upon. So if the witness is going to tender documents, it should be reflected in the witness statement. It should be reflected in the witness statement. And then if you do it well, as I indicated, usually in practice, the plaintiff will use the what you call the alphabet to label the exhibits. Exhibit A, exhibit B, C, that order. And then the defendant will use the numerals, exhibit 1, 2, 3. So when you are writing the witness statement, you have to start labeling the exhibits. If you do it properly, it will make it easier for the court. Otherwise, when it comes to case management, the court may have to take the trouble to label or renumber the witness statements and ensure that everything is in order to facilitate smooth trial of the case, eventually when it is set down for trial. Now, the importance of this new development, especially the fact that you should serve a witness statement, is that it enables each party to disclose the substance of the evidence before trial. Of course, the pleadings have given you an idea of the person's case, but the pleadings are just the bare bones, isn't it? The evidence is the flesh. So now the witness statement is going to give you a good idea of the substance of the party's evidence, as it were. And again, it will allow the opposing party to prepare cross-examination in advance. So one advantage of this CI 87 by saying that you file witness statement is that it will enable an opposing party to prepare for the cross-examination. In the past, before CI 87 came, when you are doing trial, it was a bit cumbersome because you go to the court, the trial starts, and I think I'll give you some, when it is 6, I'll give you 5 minutes break, and then you come. Now, under the old system, you go to court, someone enters the witness box, is giving evidence in chief. Sometimes can be quite elaborate. As soon as the person finishes, the judge will say that, counsel, start your cross-examination, do your cross-examination. You must finish your cross-examination today. You see, now, yes, the judge will, some judge will take that position, and you have to do it. And if we say you won't do it, some judge will say that he's discharging the witness. And if the witness is discharged from the boss, it's discharged from the boss. It's very difficult to recall a witness. It's possible, but it's difficult. Because the test for recalling a discharged witness is very stringent one. But due to the reforms we have now, it's easier. Because when you get the witness statements, you're able to prepare the cross-examination. Because the person cannot say anything more than what is a witness statement, isn't it? So you're able to prepare your cross-examination. Then there's something called the pre-trial checklist. Pre-trial checklist. It was introduced by the CI 87. So if you look at the Order 32 Rule 7A again, it will tell us that the party shall lodge with the registrar a pre-trial checklist 4 clear days before the date fixed for case management conference or pre-trial review, or both, or any other date as the judge may order. So there's a document we call pre-trial checklist. And as the name suggests, when you say checklist, what is the purpose? Checklist is just for you to make sure that what the law requires, you're able to take the boxes, isn't it? Good. So in the same vein, if you look at the Rule 7A, the checklist will confirm whether pleadings have closed. There's actually a template. Yeah, there's a template. Go to the back of the rule, Form 13A. Form 13A. So if you look at it, essentially, the checklist will confirm whether pleadings have closed, whether this, and do you know why we're saying whether pleadings have closed? It may well be that you requested for further and better particulars, and someone has provided the better word particulars. And I have seen in practice, and I even done some before, some years ago, where you are doing your defense. You actually put in a statement that waiting, like you are expecting a response to further and better particulars before you can actually indicate your position on paragraph 456 of the statement of claim. So maybe paragraph 456, you have requested that the plaintiff should provide further and better particulars. And not until you get them, you're not in a position to either deny or admit. So let's assume that that was how you set up your statement of defense. Then obviously, your statement of defense is not that complete, isn't it? So it will be like a typical case of where pleadings are not properly closed. Because when you get the further and better particulars, we have to do some amendments of your statement of defense to do that, as it were. And then the checklist will also confirm that discovery obligations have been satisfied. As you look at it over there, have all others in relation to expert? No. Are any interrogatories outstanding? Yes or no? If yes, you write. If no, you write no. If so, when said and upon whom? So this will have to be indicated. But interestingly, when you look at it, a lot of, I can say about 95% of practitioners, they don't make use of interrogatories and discoveries. So all the time, you will see nil or not applicable. If we look at a lot of file checklists, but as I said, the discoveries and interrogatories, if you learn them well, it will make you a great litigation lawyer. You can be doing well with a lot of cases. Then other things which will have to be indicated in the checklist are all others in relation to expert, factual and hearsay evidence to comply with. Remember, when we are talking about the 32 rule 6, remember the 32 rule 6? It made reference to the fact that part BII, which is the hearsay rules under the Evidence Act, the court will have to make the necessary directions. And that is why the checklist is saying that have all others in relation to expert, factual, and hearsay evidence to comply with. If no, specify what remains outstanding. B, do you intend to serve or seek leave to serve any further report or statement? If so, when and what report or statement? Sometimes you may even need to subpoena a witness. You are students of law of evidence, so I'm not going to teach you subpoena, ad tecum, and subpoena testificandum. And you may need to subpoena a witness, either to come and just testify or to come and tender a document. So if that is needed, it will have to be indicated so that at the right time, the subpoena will be issued and then served on the particular person to come and testify. Then have all others in relation to evidence comply with. No, sometimes we have commission. It's possible for you are doing a lot of evidence, so you know this, or you've also done a criminal procedure. It's possible for the court to make an order that a particular witness, maybe who is bedridden somewhere in, let's say, Tamale, he or she doesn't have to come all the way to Accra. So orders can be made for him to testify in the nearby court. And then for his evidence on commission of the position to be transmitted to the particular court where the matter is being is being tried. So that is possible. But these days, we even have like a video link evidence that may not be so much a problem because you can even arrange to have the video link sent to wherever the person is, and then you're able to get the evidence. Then, do you require any further leave or there's relation to evidence? If so, specify. So the checklist basically is to help the parties and the court to prepare meaningfully for the trial, so that when the trial starts, the trial can proceed. You can start a certain number of days. Say that I'm going to do 3 days, or I'm going to do a 1 week trial. And it should be possible for the trial to be completed. Because if you've done proper preparation, and if the case management and everything are all done properly. So that is the point about this. So the purpose, as I said, is to ensure that all preparatory steps are completed before the case proceeds to trial. Now, where a party fails to comply with the direction given during case management proceedings, there are consequences. The court may impose sanctions. If you look at Order 32, Rule 7A3, and there's a matter on somewhere. Yeah, so the court or the judge may strike out the action if the defaulting party is a plaintiff. So if the court has asked you to do something and you haven't done it, if you are the plaintiff, the court may actually just strike out your action. Or if you are the defendant and you have a counterclaim, the court may strike out your defense and counterclaim. Or if you don't have a counterclaim, your defense can be strike out, as it were. Or the court may order any party to pay cost or make any other appropriate order. Now, as you speak now, if you look at Order 32 7A, paragraph 3, a range of sanctions have been set out as what the court can do, where directions given or orders given at case management conference have not been complied with. It is not clear whether those sanctions are arranged in a certain order so that the court must necessarily exhaust a particular sanction before it can consider the rest, or it's really up to the court. Look at the rule and tell me what you think. Look at the law and tell me whether you think that in terms of A to D, there's no hierarchical order, and the court is at liberty or has a discretion, depending upon the circumstances of the case, to deploy any particular sanction, whether to strike out the plaintiff action or strike out the defendant defense. Or the court does not have to do that. The court might just award cost first, and then subsequently, if it is not comply with, before it will consider striking out theirs. What do you think? Yes? What do you think? You have your law, don't you? Yes. But is it the same thing? Okay, yes. That's the 2-7. I'm reading from the CI. It is 7. So there are amendments, like they have added some things to the CI 47. I've taken a few things out. Yes, so that is it. So there's 7 in Rule 7 of CI 32-7. CI 47 is still there. In addition to Rule 32, Rule 7, we have also added 7A. So 7A is add on. Yes. Yes, what do you think? You have no opinion. Okay, if you have no opinion, we can continue. You have opinion, yes.
I'm thinking that the court should first award for striking out there.
Why?
Before,
I'm interested because I speak to you now. It's a one big case we are dealing with, and the input will help us.
so in my opinion, I think the court should award costs before striking out the action. Because if the court doesn't award costs and the court strikes out the actions, it will be to the other party's disadvantage. Because if the party who didn't comply, right, it's putting the other party to a disadvantage. Why should the court just strike out without taking into consideration the other party's disadvantage? So I think the court should actually award costs to the other party before striking out.
No, see what is happening. You have a plaintiff and defendant. Let's say the court has given certain things you are supposed to do as a plaintiff. You haven't done it. The defendant has carried out all that is expected. The defendant also has a counterclaim. And you are the plaintiff, because you haven't done it, the rule says that the court may strike out.
Yes, so if the defendant has done it, it's the defendant's cause. So the court should first award the defendant before striking it out. Because if the court strikes it out right now, whatever the defendant's
Counterclaim.
yes.
The counterclaim will continue.
Yeah, it will continue, but then should award the
Cost in favor of the
yes.
and allow the plaintiff case to stand.
Yes, that's the idea.
Okay.
Because that people will just take advantage of it and then do otherwise, because they know that if I don't how do you call it, even if I don't comply, in the end you just strike out my case. People will take advantage of the law and then
No, but striking out is more serious than the cost. Because your case is strike out, it's like your case is finished, isn't it? Unless you can get
so
yes.
you strike out, but then award cost before striking out.
All right.
At least you strike it out.
Please, let's have silence. Yes.
That if it's being struck out, I'll pay something for it being struck out.
All right. Thank you. Okay, so let's talk about ADL as part of the case management. CI 133. Just a few minutes, then you go for the break. I want us to finish this session. So, if you look at the CI 133, which is another amendment to the CI 47, it has also introduced provisions that allow parties to request a civil proceedings in order to attempt what? Settlement, as it were. It's permissible for the court, even at the application for direction stage, to make orders referring the parties to ADL. So if you go to the Accra Court Complex, for example, we have what we call the court connected mediation. You have the ADL rooms and the rest. So ADL practitioners who have been certified and they are there, and this without prejudice. So you go to the ADL, and if it works, well and good, usually within 1 month. If it doesn't work and you have to continue the trial, then the necessary arrangement will be for the trial to be completed. Because there are a number of disputes. If the parties are assisted, it can be resolved without going through the trial process for the court to pronounce the at the end of the trial. There can be ADL, terms of settlement are made, and then to be adopted as a consent judgment. A consent judgment is a judgment in all sense of judgment. It has the same binding effect as a judgment at the end of what? Trial. But the advantage is that consent judgment is the parties themselves who have reached their deal, as it were. And the court is only giving judicial imprimatur or approval to what they have agreed. Yes.
So I didn't stay before the to the area.
Before?
Prior.
Oh, sure. Anytime. Yes, it's not before trial, not after trial. Trial is where the ADL has not worked. But even then, ADL is always a possibility. ADL is always a possibility. before start of the case, doing pleadings, at the application for direction, case management, during trial, even judgment. The parties can have a judgment and still compromise the judgment. If the court has given you a judgment, it doesn't mean that man necessarily enforce it. You can reach agreement to say that, yes, we note that on this and this and day, the court gave a judgment this. However, we have resolved that this should be the position between them. That is also possible. People can even litigate to Supreme Court, get the judgment and still reach agreement, which will compromise what? The judgment, not go strictly by the terms of the judgment, do some other things. No court can force a person to, two parties to necessarily take the judgment if there's that mutuality. It is only where there's no agreement before the authority of the state be thrown behind someone according to the terms of judgment against the other party. Or if both parties agree, then there's no problem. Okay, so we'll have a break. When we come back, we look at the commercial court briefly, and then we move on to discuss application for directions, not injunction, the 25. And then we're at that trial. We discuss trial, and then we will end for the day. So we have a 10 minutes break. So at the say 17, I'm expecting you back.